Welcome to the Garrulous Gavel. I'm John Tico, and welcome to our first episode of 2022, which features a discussion with Timothy O'Toole. Our topic is how the United States uses export controls as a tool in U.S. China relations. The United States and China have one of the largest and most integrated trade relationships that two countries have ever had in the history of the world, and yet we are also competitors on the world stage, militarily, ideologically, and for influence. And we'll be talking with Tim about the law relating to the transfer of military goods and technology to China. And we'll also be talking about how the United States uses trade laws to try to respond to human rights and civil rights abuses in China that we've read so much about recently in Hong Kong and in Xinjiang. And this is a really interesting conversation from a super knowledgeable attorney. And then once we get past that topic, we're going to hear about Tim's new wave band from the 1980s that he had in college, a band whose debut album was called Canoe Wave. So stick around to listen to that fun conversation, and I hope you enjoy the whole thing, and thanks for listening. And hey, by the way, if you like listening to this show, please leave us a rating, give us a comment on whatever app you are using to listen to this, or if you're watching on YouTube, you can do it right there. You know, sometimes I feel like I'm just talking into the void. I see the statistics. I know that lots of people are listening. I know you're out there, and it's time to start the feedback loop. Give us a little bit of feedback that keeps us energized. You can give us suggestions to make the show better, and it's a way for us to connect. So just please take a moment to do that, and we'd really appreciate it. And I hope you enjoy this conversation with Timothy O'Toole. Hello and welcome to the Garrulous Gavel. I am your host, John Tico, and my guest today is Timothy O'Toole. Hello, Tim. How are you today?
Hey, John. How are you doing? Glad to be here.
I'm doing pretty well. Tim is joining us from Canada remotely, and but he is actually a Washington, D.C. based attorney stuck in Canada because of this little thing called the COVID pandemic that you may have heard of. We're going to have a really interesting conversation with Tim today. Our main topic of the day is going to be U.S. China relations, and in particular, the use of what are called export controls or maybe embargoes. And maybe Tim will explain to us the difference or not, whether there's overlap between those two terms, how the U.S. uses export controls as a tool in its relationships with China, which are becoming a more important and more interesting topic almost by the day. I noticed in the newspaper today, on at least the front page of the Wall Street Journal, there were 3 different articles that touched on trade issues with China. So these are becoming sort of common, important, and recurring issues. And then at the end, stick around for it, because Tim is going to tell us about his early pre-law career as a rock star, where he was the rhythm guitar player for a 1980s New Order style rock band, and I'm sure we'll hear some interesting, fun stories about how that came together and went down. So stick around for that. So we're going to start, as we normally do, by just learning a little bit about our guest. So Tim, let's just start with, where did you grow up?
Hey, John, thanks. So I grew up in a little suburb of Richmond, Virginia, for the most part. We moved around a little bit. My dad was a college professor, my mom a lawyer. And so we lived for a year in California when my dad was a visiting professor. We lived in Ohio a bit when he was getting his PhD. But for the most part, born and raised, and definitely born and mostly raised in Richmond, which was different time and weird place to be, I think, in the early 70s.
What was weird about it?
Well, I mean, it was going through a lot of changes. I think, I barely recognize Virginia now, and almost in a good way. Virginia was, Richmond was the capital of the Confederacy. Virginia was a very, very, very different state than it is currently. And the 1970s in Richmond were going through a lot of changes. I went to an elementary school that was a fusion of the white school and the black school. And so we had second and third grade in the formerly black school, and the other grades in a different school. And it was, thinking about it, it was just like all kids. You just go through it and you think it's normal. But looking back on it, it was a time of huge change and tension and kind of a weird place to grow up. I think I learned a lot from it. I think in the sense that a lot of this stuff that you read about in history books, it seems almost not real, but it definitely was real to me.
Yeah, you and I are getting old enough that we actually remember some things that are now history, right?
Exactly.
So you said your mother was an attorney?
She is an attorney, and she doesn't practice anymore, but she's still an attorney. But she actually went to law school when she started law school when I was, I think, 7 years old, and got her JD at the University of Richmond, and then she was a trial lawyer for about 40 years. Tried a lot of cases.
That's fascinating. And was that sort of the inspiration for your interest in law?
Yeah, it really was. I mean, for some reason, I always had this thing in the back of my mind after I gave up on the dream of being a baseball player and a rock star. I think it was that I always really thought that I'd wind up in the law. And my mom was very happy with it. I kind of knew what the law was about. And I, I'm really happy that I made that choice too. But yeah, I think it was mostly because of my mom.
And was that, did you sort of come to that realization sort of early in life, or
pretty early? I mean, I think, it's certainly by high school, I thought, if it was clear by then baseball wasn't going to work out. And I still thought maybe I would be a musician, but by college, it was clear, not necessarily that wouldn't work out, but that it was a crappy way to live. I mean, the thing is that, obviously it's nice to be, the Rolling Stones or the Beatles or some, huge group. But mostly, I think musicians that make a living at it are kind of spending a lot of time driving around from crappy bar to crappy bar and trying to do business development in the same way lawyers are, but I think it's with a seedier crowd often, and it just didn't seem like much of a way to live when I got into it. It also I may well not have had the talent to do it either, but it was one of those things where as I got to the point where it was either law or music, it was pretty clear that music was not a great path.
Yeah, that's definitely true. I mean, I know a lot of lawyers who had artistic ambitions of one sort or another earlier in their careers, and law tends to be a career that's kind of good for people that are generalists. And so I think there's a lot of musicians and theater people and artists of various sorts when you talk to lawyers, or at least that's been my experience.
Mine too. It's really interesting how that works out.
Yeah. So you went to both college and law school at the University of Virginia, is that right?
I did.
At least that's what your law firm bio represents to the world. And
I can tell you that is true. So, but yeah, so I basically, went 60 miles from home to law school, and to undergrad, and spent quite a bit of time in Charlottesville. Actually, we'll talk about it later, but my band played at the same bar that ultimately Dave Matthews was not only discovered at, but he became the regular act before he took off. So, we were just behind Dave Matthews. There was a huge talent gap, but we played at the same bar.
Well, maybe a talent gap on guitar, but I bet you're a better lawyer than Dave Matthews. So.
Let's hope so.
So your career path, and I guess we'll kind of go through it a little bit to kind of get to where you are today. But you spent a fair number of years as a public defender in a couple of different jurisdictions. So I take it that you must have developed some interest in kind of criminal law and criminal defense. When did that interest kind of start?
So it's interesting. And this is kind of a shout out to the people who go to law school and finish and don't really know what they want to do. I finished law school, went and clerked on the Nevada Supreme Court. It was actually they sit right near Lake Tahoe, so it was a really nice place to clerk. And then went to a firm for a couple of years. Was at a firm in San Francisco, or actually in Oakland, for a couple of years. Worked with some lawyers there who had been death penalty lawyers in California before they went to work for a big firm, and they talked to me quite a bit about how I guess satisfying, but it's not the right word, but how important that work was. And one of the lawyers at my firm had a friend in Nevada who was kind of the head of death penalty litigation in Nevada. And so I went to Nevada with really the idea that I was going to go do death penalty litigation in Nevada, and wound up working on about 25 or so capital cases while I was there. There were about three of us. They were really the resource for the last appeal, the federal habeas corpus appeal, basically when you got to federal court. And so we were representing people who'd been convicted and sentenced to death in state courts, but they were appealing under federal habeas corpus in federal court.
And that was through a sort of a state public defender's office?
First with the state public defender's office. I worked on a case with the federal defender group that did this, and then after the first case I worked on, I got hired at the federal defender to do the same thing, but only in federal court.
I think you're the first guest we've had on who worked as a public defender. So maybe it would be interesting to the listeners just to get a little bit of background about kind of what a public defender's office is and what it does.
Sure. And I think, I'm lucky in a sense because I've kind of seen the whole gamut with public defenders, but public defenders represent people who don't have enough money to pay for lawyers. And so, under Gideon versus Wainwright, the states are obligated to give free counsel to people who can't afford it. And as a result, most states have a public defender system. Some states, at least the last I checked, and I have to admit it's been a while, didn't have systems, but what they did is that you would get a court-appointed lawyer, so the court would appoint someone to represent you if you didn't have a public defender system. And so I worked for the state public defender system in Nevada, which was a good, dedicated office, but had very, very few resources, and so not much training. You were just kind of thrown into cases. You had a huge caseload. I was lucky enough that I was doing mostly appellate work there when I got there, and so I had lower caseloads than some of my colleagues, but I would also kind of just show up at initial appearances and represent people who had been arrested the night before, and we were trying to talk about release from jail and that sort of thing. And then I did some capital cases on appeal for the state public defender's office, and these were people in the state system. The federal system has its own public defender system, the federal defender systems, that same principle. They get, you get counsel if you can't afford it when you're charged with a crime in the federal system. And they also have a system that allows for appointment of federal defenders. At least they did in that jurisdiction. They don't everywhere. If you'd been sentenced to death in the state system and wanted to file a federal appeal, which you have, one federal appeal as of right if you've been sentenced to death in a state system.
So when I was in college thinking about going to law school and wanted to get a little bit of exposure to working lawyers, I lined up a summer internship with the Baltimore Public Defender's Office and spent a couple of months just sort of shadowing a couple of the lawyers in that office. And this is going back 30 years now, but my memory of it is that the kind of what made the lawyers in that office tick was a lot different than what I've encountered from lawyers in other types of practices, in the sense that they often knew that their clients were likely guilty of something, not always, but that a high percentage of them were, and that they were going to either lose or have to plea a very high percentage of the cases that they were working on. And my sense was that what was really motivating them to get up in the morning and do that over and over and over again was the sense that they were the institutional check on the police and on the prosecutors, and that their real job was to keep the police and the prosecutors honest. What's sort of your reaction to that impression that I had 30 years ago?
Yeah, I think that was my impression through, that was a lot of what was going on in all the offices that I worked with. I will say, so I was at the Public Defender Service in D.C. It's kind of my third public defender's office that I was in when I moved back east. And I think that there, I think it was also, there were two aspects to it. One was the check on the police and the prosecutors, which was a big part of the aspect. But the other was the importance of the clients. I mean, I really do think that PDS was lucky and unique because it's known as the nation's best public defender office, and it's got good resources. And when I was lucky enough to run one of the divisions there, for every job opening we'd have 700 Ivy League students who would apply for it. I mean, seriously, we would have 30 Harvard grads for every job we had open, and every other law school that you can name. And so there, I think that what they were really looking for was kind of what they call it there is the best representation money can't buy. And it really was, not only was there this like pride in checking police and prosecutors, but that these were people who basically had been kind of spit out by a system that had forgotten about them. And there was looking beyond, whatever they were charged with doing, it was a real pride in being able to give people who had never been treated well by the system before a real chance and real hope.
Yeah. Yeah, no, that's great. And so to just sort of pick up the chronology, so you worked in both the state and the federal public defender's offices in Nevada, and then you moved to DC and you worked in the federal public defender's office in the District of Columbia. When did you make that move across the country?
So when I got out of law school, I had lived basically in Virginia my whole life and really wanted to go out west. Was out west for about 10 years. I made the move back across the country in 2000, just because it's, I'm still very close with my family in Virginia, and being 3,000 miles away, you miss a lot of important events. So in 2000, I decided to come back to DC and was lucky enough to get a job at PDS, and wound up doing some interesting work there.
Yeah, so you were the chief of the Special Litigation Division.
That's correct.
What is the Special Litigation Division?
It really is kind of the greatest job ever. So we basically decided and it was not that hard to make some of these decisions, but we got to decide, what systemic criminal justice issues are really affecting our clients and how do we deal with them. And so sometimes, when I was working there, a couple of the big systemic issues that we were focused on were eyewitness identifications and Brady issues. And Brady, for the non-lawyers out there, Brady is the constitutional right to have the prosecutor disclose any helpful evidence that it has in its files to the defense. That is, that it's kind of an exception to the adversarial system, because prosecutors have the police at their disposal, have all of the state resources at their disposal, so they're required to turn over things that they find that might help the other side, so that you have a fair trial and not one where the best evidence is in the police files. And so those were two issues that were really important. There were a number of others, but we would attack those issues however we thought best. So sometimes if there was a trial that the trial lawyers had and there was an eyewitness identification that was very critical, we'd help work with them to find experts or to develop the eyewitness, the problems with the eyewitness testimony, because there was a lot of, and there still is, but at the time the social science research was really just coming into vogue. And so, it's long been known that there are flaws in eyewitness testimony, but social science researchers had started to figure out the circumstances in which that evidence, you could put kind of data and metrics to show what some of the flaws were. So we'd come in and we'd help the trial lawyers work with that because we were familiar with the science on that. We we did other things as well. So we actually sued the DC jail in federal court because they were getting millions of dollars a year to provide special ed for, at the time. I mean, I think they still do it, but I think the climate has gotten better now. But they used to lock up a lot of kids in the DC jail and charge them as adults. And they had these kids were supposed to be in school, and the DC jail was getting millions of dollars a year and for a special ed program. And unfortunately, a lot of the clients who wind up in the criminal justice system do have kind of special needs in terms of education. DC jail did nothing. I mean, they really had no program whatsoever, even though they were getting a bunch of federal funds to do it. So we sued in federal court to force them to set up a special ed system in the jail. And so that was another kind of issue that was affecting our clients that we were able to.
It sounds like a False Claims Act case, the kind of stuff I do.
Yeah. It probably was. We weren't smart enough to think of it that way, but I think we just brought it under the special ed laws.
No, that's great. And so you were there for about 7 years, is that right?
Yep.
Yeah. And so then at some point you decided to go back into private practice. What sort of led to that shift in your career?
Being a public defender is a very hard job. It kind of grinds you down. And I was lucky enough to have some of the best public defender jobs, but it really, you get to a point where you see people who've been in it too long and they burn out. Now, I didn't get there, but I was kind of at a point in my career where it was either be a career public defender or do something else. And I just was very scared that if I stayed, that I would burn out. And so, I went into private practice to try something new and have really liked it.
And when did you get interested in or start to intersect with these trade issues that you deal with now? I assume that that's not a common issue in the public defender's office, although I could be wrong about that. There are criminal side to it, right? Yeah,
there is a criminal side to it, but I might be the only former public defender in the trade space. I haven't come across another one, so it's not a common career path. There's trade violations, and we can talk about it more when we talk about kind of just what the law is. But trade violations all have a criminal side. In kind of rare cases where somebody does something willfully, they know what the trade laws are, which is tough enough, and then they intentionally go out and violate them. Trade cases can be criminal, but I didn't have any trade cases at the public defender. I did once I got to Miller Chevalier, and it got me very interested, but also got me convinced pretty quickly that you couldn't do those well by just dabbling. The rules are too complex.
Yeah, so maybe just say a word about how you made the transition and how you picked Miller and Chevalier, a great firm here in Washington, D.C., as your landing spot.
Yeah, so that was something that really concerned me about making the transition, because I'd been a public defender for a long time. And, one of the nice things about the public defender service office, although as a manager there, it was a less nice thing, is that, public defenders as a whole are kind of like herding cats. And so you had kind of a level of independence, also a level of kind of, I'd say, noise is probably the best word for it, that is not common to Washington law firms. And so, occasionally there were fights in the hallways. Occasionally, people would yell across the hallways to somebody that they were working with. There was just a level of noise and buzz at a public defender's office that, I was a little worried about going to a firm that would be much quieter than that. And Miller Chevalier is much quieter than that, to be quite honest. But I was worried about kind of the culture shock in terms of the transition. And at Miller Chevalier, there were a few lawyers who I had worked with at PDS, and some others that I hadn't worked with but knew of. There's a guy named Mark Rochon, who's kind of a PDS legend, who was at Miller Chevalier when I came over. But Miller Chevalier actually has hired public defender service lawyers for years. Jim Bensfield, who was the training director at PDS in the 70s, started our white collar group and is still there, and a bunch of other public defenders. So I felt more comfortable there, although when I got there, it was very quiet.
And so did you go there with a plan for how you were going to find or build a practice, or did you show up and then have some conversation where somebody said, we could really use some help with these trade cases? Or the entirety of my career was
pure happenstance. For the first 3 or 4 years that I worked there, I basically just kind of worked on what anybody gave me to work on. I was trying to develop a practice. I was, on the board of the National Association of Criminal Defense Lawyers, making contacts, doing things to try and build a white collar criminal defense practice. But, was also coming out of government, kind of dependent on the generosity of others in terms of what I worked on. And so I worked on, I wound up working on an Iran sanctions case with some of the trade lawyers there. And I thought, this stuff is really interesting. I'd like to do more. And so I wound up, really going to CLEs. I actually went to one of our lawyers taught a class at Georgetown Law on economic sanctions and export controls. So I went and actually took that class at night, just to see what was up with that. And then, went to some CLEs and did some writing. And so it was kind of the firm gave me a lot of leeway to do that, but a lot of it I did kind of, off hours. And so, because it was a lot of learning, and a lot of learning that you couldn't get clients to pay for and the clients shouldn't pay for. So I wound up kind of learning on my own.
Right. Yeah. But I think that's a great story. And it kind of says something about lawyering as a profession, that one of the nice things about it is that you can sort of make these transitions to sort of whole new substantive areas periodically. And that's happened to me a couple of times. In my career too, where largely through some unanticipated fluke of luck, you suddenly get drawn into some new area that's interesting, and you can then kind of use that as a jumping off point to sort of build a little bit of a practice around something that you enjoy. And that can happen multiple times over the course of a long career.
It's my favorite part about the law, quite actually. I mean, I was for a while an expert in death penalty law and habeas corpus, and an expert in eyewitness identifications and Brady issues and issues involving the treatment of prisoners. And then, to go from that to trade law and sanctions has been quite a journey, but it's also keeps it interesting. I mean, I like I mentioned, one of my real concerns as a public defender was the possibility of some point burning out. And, the wide variety of topics that are out there as a lawyer it really helps prevent that.
Yeah, just transitioning to something new can be like a jolt of energy, I think.
It's like a new job, really.
Right. Yeah. That's great. Well, so thanks for that little march through your career, and you're still happily at the firm now. And so let's turn to the substantive topic that we had decided we would talk about today. And this is really in sort of your new area of specialization, which is trade law, and in particular, the export side of trade law. There's also an import side of trade law, which my practice intersects quite a bit, because I've done a lot of False Claims Act cases involving customs fraud. And those cases almost always involve imports from China as well. And so a lot of trade law touches on things that are happening with China, not surprisingly. So let me just kind of like take a minute to kind of set this up a little bit, just to kind of give the listeners a little bit of like what I see as kind of the historical background to why all of this is happening and kind of why it's interesting. Because the United States has a very sort of interesting history with the Chinese government. So for people who don't know, the People's Republic of China was created in 1949 by Mao Zedong, who was the head of the Chinese Communist Party. And there had been essentially a civil war that the communists had won. And the other side of that civil war, they were called the nationalists. They fled as they were losing the war and went to Taiwan, which is why we have this China-Taiwan split even to this day. And pretty soon after that, I think within a year or two of that, the Korean War started, and the United States and China found themselves on opposite sides of an actual shooting war. And we basically had no real diplomatic or trade relations with China from that point until the early 1970s, when President Nixon made his famous visit to China. He was the first president to go over there. And that began sort of a slow thaw in both diplomatic and trade relations between the United States and China. And very slowly, the United States started doing a little bit of trade with China starting in the 80s and accelerating a little bit into the 90s, but they were still pretty far down the list of countries that we had an active trade relationship with. And then in around the year 2000, when Bill Clinton was president, we had the U.S. China Relations Act, which normalized trade between the United States and China, and which led to China joining the World Trade Organization. And China's economy was starting to pick up around that time as well. They were becoming a larger and more active manufacturing economy. And really from 2000 until today, there has been an almost steady and unbroken skyrocketing of trade going in both directions between the United States and China, to the point that now China is the country from which we import the most goods relative to any other country in the world. I just looked at the USTR most recent statistics that said in 2020 we imported about $434 billion in goods from China. That's just goods, not services. And we exported about 124 billion of goods from the United States to China. So there was a trade deficit of about 313 billion favoring China. So they're the number one country for imports. I think they're the number three for exports. I think we still export more to the other NAFTA countries, Canada and Mexico, than we do to China. But while this sort of explosive growth in our trade relationships was happening, China was also slowly becoming a bigger and stronger power in other ways, and in particular, a bigger and stronger military power, a bigger and stronger political power in other parts of the world. And we find ourselves really, I think, maybe over the last decade or so, of starting to see those two trends kind of colliding in various interesting ways, where really for the first time in modern history, we have a situation, I think, where we have two countries who are major competitors on the world stage for military power and political clout, but who are also massively intertwined as trading partners. And you can sort of just compare that to sort of the Cold War, where we had a major military and political adversary in the Soviet Union, but it was a country with whom we really did not have any trade. So that was not a major consideration in our relationships with the Soviet Union. But trade is a major part of our relationships with China, and I think that has led over time to an increase in law around this issue, and why it's become an interesting legal issue, because both the importation of goods from China and the export of goods and services from the United States to China have become more and more heavily regulated by the United States government, often because of security or political concerns military security and political policies that the government is trying to implement through trade policy. So I'll stop there. That's my high-level introduction. Did I get it about right?
That was great, and like really quick history of kind of not just China, but also trade policy in China. So that was helpful.
Okay, great. So, but now I'm going to turn it over to the real expert in this, Tim. And maybe you could start by just giving us at a very, high level, because assume the listeners here are not other technical lawyers. They're just regular people who are interested in this, in kind of how the world works. So give us kind of a high level description of what export controls are and kind of what are the tools in the toolbox, if you will.
Sure. So really the history of export controls in the U.S., there actually was an Embargo Act in 1807 because the British were harassing U.S. trading boats that were going over to Europe. It was wildly unsuccessful because, as you might imagine, a small new country that tried to put an embargo against Great Britain failed pretty miserably, and so the U.S. kind of put that back in its pocket and didn't really try again until World War One. In World War One, Congress passed a law called the Trading with the Enemies Act. That was really a wartime law that was designed to stop trade with once the U.S. got into World War One, designed to stop trade with the other countries that were involved in the Germany and the countries that were the enemy in World War One. And so that law was really the first new set of quasi-export controls, but again, like the Embargo Act, it was really an embargo, a type of export control, but more sanction. If you fast forward to World War II, the U.S. started to set up what is traditionally now viewed as the first real export control regime that has been in the U.S. And so export controls are any law that is designed to regulate the exports from a particular country by having the government kind of take a position on whether the export is allowed. Sanctions are a type of that because they're a type of restriction on exports because we're trying to either stop a particular policy of a particular country or punish a particular country. Export controls is a more global regime. So essentially, we have export controls with respect to every export that takes place to any country in the world. It's kind of not a tool that is used to punish a particular country. Now, the rules with respect to what you can send to a country are very different. And so the way they basically work is every export that goes anywhere is potentially regulated by one of two agencies. The State Department regulates exports of military products. So as you might expect, there are some pretty strict restrictions on what sorts of military products that can be sent out of the country. And so the level of restriction depends on what the good is, how it's classified, and then where you're trying to send it, and then really who you're trying to send it to within that particular country. And so the State Department regulates those things. It's the laws now, I think it's a 1976 law that's called the ITAR, the International Trafficking in Arms Regulations that are administered by the State Department. But they're really the rules that govern what you can export in terms of military products, and very complex set of regulations, but that's the gist of it. If it's not a military product, so it's not on what they call the munitions list, and there really is just like a list of what sorts of products are considered military products, then it's the exports are regulated by the Commerce Department. So the Commerce Department regulates all exports that are not military goods, and then they have a specific list in the Commerce Department. It's called the Commerce Control List, and that is dual-use goods. So if it has military uses, but it's not really a military product because it also has civilian uses, those items are on the Commerce Control List, and so there's a specific set of regulations that apply to those sorts of goods. So dual-use goods have lesser regulations than military goods. If it's not on the Commerce Control List, then it is treated as a pure civilian good. The Commerce Department still regulates it, and there's some restrictions on those sorts of goods. If the trade lawyers would call them EAR 99 goods, so that just is a code word for the fact that it is non-military. It has no military uses. So like your refrigerator, if the company was trying to export a refrigerator from the U.S., the refrigerator would be EAR 99 because you're just not worried that if you send it to a foreign country that they would be able to use the refrigerator for any military purpose. So that's kind of one set of export controls rules, and really you have the Commerce Department regulations, the State Department regulations. The difference between the two is one is military, one is kind of dual use, but they're all based on what is the good, where's it going, and who's going to use it. And then the separate set of regs that, the economic sanctions piece is administered by the Treasury Department. So the Treasury Department has a bunch of programs that are pure what they call economic sanctions. And those are the ones that are kind of, if the U.S., they're actually the ones that you read about most in the paper, although the fact is that the Commerce Department and State Department regulations with respect to China come up a lot too. But if you see a program like the Iran sanctions, that's out of the Treasury Department's Office of Foreign Assets Control, which people often refer to as OFAC. So OFAC administers sanctions programs. So the Cuba sanctions, the Iran sanctions, some of the Chinese sanctions are administered by OFAC. But that's kind of, in a nutshell, the three kind of tiered level of export controls in the U.S.
I have so many questions already.
All right, that's great.
So let me start with this one. So on the either the military goods or the dual use goods, it seems to me there are a couple of sort of obvious questions to ask about that. So one is, if we are selling the military goods to other countries, but there are particular countries that we don't want to get their hands on those particular, I don't know, let's just say a weapon, right? How does the United States control what happens to those things after they've left the United States?
So it's in some ways self-policed, but it is some ways, very tightly regulated in terms of, who does the policing. So for almost every military type good, you need a license to send it to out of the country from the State Department. Not always true, but I'd say 98% of the time a license is required. To get a license, the State Department will ask some very serious questions about, who is this going to? How's it going to get there? Who's going to be involved with it? What's going to happen to it when it gets on the ground? And so, most of the sales of military goods are going to go to governments, allied governments usually. And so they'll be, you'll have some control over that. You won't have full control over it, but you'll have some control over that. But even the sales that aren't going to foreign governments are going to potentially to companies that are U.S. companies that have overseas offices and they will make representations about what is going to happen to the military good, where it's going to be, what it's going to be used for. And a lot of questions get asked during that particular process. And so the State Department license will be very, 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 a lot of minutia. It'd be very specific about what you can and can't do with the license or with the good and who gets to use the good. And U.S. manufacturers and U.S. exporters have to be registered with the State Department even to send the export in the first place. And so there's a lot of incentives to do this well, because you can lose your exporting privileges if you don't. You can, and there's a lot of checks in the system. It's part of the licensing process to make sure that what you're selling is really going to the people that the government thinks should be permitted to have it. But right. It is a good question. I mean, that's the danger of exporting a military good, is that it could get into the wrong hands.
Are there certain goods that are made by U.S.-based defense contractors that the government just will never allow to be exported to anyone?
Yeah, I mean, they're really. I'd say anyone might be a little bit harsh, but outside of kind of the countries that you would think about as kind of the closest U.S. allies, the idea that any of those would get anywhere else the chances are pretty slim. And I think part of it too is. So there's two aspects to the export regime in terms of why we do it. One is, for military goods, we just don't want the goods themselves getting in the wrong hands. But then there's also the reason that we regulate, even goods that are not necessarily militarily, is that they have technology in them that could be recreated or could be stolen. And so you also kind of want to restrict the possibility that that's going to occur as well. And so I think, with a few exceptions, there are some high-level goods that really, it's not even worth thinking about trying to get a license.
Okay. And so that kind of leads to the next question I had in mind, which is, what is the internal process for figuring out what goes on these lists? Now, I assume some things are kind of obvious.
Right.
If it's just literally a weapon, right? Okay.
Yep.
But particularly in the dual use questions, I assume that figuring out what types of technology could have dual uses must be a highly technical question, and that the answers to those questions can really only be answered by engineers in specialized fields. If we're talking about computer technology or materials technology, so I mean, what can you tell us about sort of what is the process for figuring out what goes on those lists?
So you're exactly right. I mean, it's often an engineering determination. And if you look, so the lists often they'll say, this item, this testing machine that has the following capabilities. And so it'll list what the testing machine can do. And if it fits that, then it gets a little number from the Commerce Department. They call it an ECCN, an export classification control number. And so an ECCN tells you this is a testing machine that meets the following the following capabilities. And at that point, once you've determined that that's what that is, you then look in other parts of the export regulations to determine, can I send it to this country without a license? Do I need a license to send it to this country? And that's based on kind of the risks posed by the country and then the risks posed by the technology. And so some ECCNs are better than others. So there's some ECCNs where the restrictions are pretty light. And those are the ECCNs that usually are allowed to go to China. With respect to China, there's a lot of ECCNs now where it's very difficult to export to China without a license. And then, even if you were to try and get a license, you often can't get it with respect to China. But it's definitely a difficult determination. Some of the categories, some of the classifications are, you get a product and you can figure out exactly where it fits. Sometimes there's a lot of wiggle room at the margins. You can actually go ask the Commerce Department to help you do the classification. So you can get a determination from the Commerce Department as to where does my product fit. They'll ask for all the brochures and that sort of thing. They're pretty good about it. They usually come back with an answer within a couple of weeks. But if you're kind of in a gray area, sometimes the safest route is to go get a determination from the Commerce Department. They call it a CCATS. So you go get a CCATS from the Commerce Department.
So I'm thinking where lawyers fit into all this. And so I'm imagining there must be some process for a company to complain about these determinations, to try to influence what's on those lists, or to complain about determinations that are made on their license approvals. Where does a lawyer like you kind of intersect this process?
So a couple of places. I mean, we help with the classifications because the list is still a bunch of legal terms that are put together by lawyers at the Commerce Department, and figuring out what they mean is part of the lawyer's job, and part of the lawyer's job is to talk to the engineers and then try and figure out what they're saying match up to which part of the list. But I think the more classic lawyer function in this area is with respect to creating the lists in the first place. So, for example, the lists change quite a bit over time. Really, in the last 10 years or so, we went through this process that was called export control reform, and the goal of export control reform was that because the military list, they call it the munitions list, that's the ITAR one, it's the military goods, it had gotten too big. And so we had all sorts of kind of leftover stuff that, in the 1960s, this was a really critical piece of military technology. Now it's kind of something that, you can buy pretty much anywhere and really shouldn't be on the munitions list anymore. And so what they did is they went through a whole process of trying to just keep what they called the military crown jewels on the munitions list, and then move the rest of the items over to the commerce control list. And then at the same time, both on the munitions list and the commerce control list, as technology evolves, you get new products that aren't accounted for on either part of the list, and you want to make sure that the newest products, which are usually the most important ones in terms of maintaining U.S. superior technology in some of these areas, that they're not immediately exported. And so there's another group at both commerce and state that are trying to figure out, well, what are the emerging technologies that need to be put on these lists. And so lawyers participate quite a bit in that process, kind of both on the committees that help to make the lists, and then also, with respect to comments, and then potentially, litigation. Although there's some restrictions on litigation in this area, and so it's much more of a administrative function that the lawyers play within the agencies as opposed to suing the agencies. That doesn't happen that much. It happens occasionally, but it's not as common as it is in some other administrative areas.
And then I assume there must be sort of an enforcement side to this, right? Where maybe a company is accused or caught exporting something that's on one of the lists and they don't have the right license, or they haven't made whatever the required disclosures are to the government ahead of time. Maybe say a little bit about that. How, from your perspective, how good are the enforcement mechanisms? And I'll just sort of preface that by saying, because I've spent a fair amount of time on the import side of things, my sense is that our policing of fraud on the import side is not particularly effective because it relies so much on self-reporting. There's just massive quantities of goods coming across the border literally every minute. And, only a very, very small percentage of those are ever subject to any sort of inspection. These just cargo containers are coming in, going out, coming in, going out. Nobody's really looking at what's inside of them. And so it is this self-reporting mechanism. And so if somebody wants to cheat, it's not that hard to cheat. Is that true on the export side as well, or is it harder to cheat on the export side?
So enforcement is the area that I focus on most just because of my background, because, I've spent a lot of time defending enforcement actions, thinking about enforcement actions. And I think I would say it sounds like it's a little bit better than on the import side. I think there's less cheating going on, and I can talk about why that is for a couple, in a couple seconds. But the thing that was the most difficult for me to wrap my mind around when I got into this practice was the level of self-reporting. That is, that companies would go in and report to the government when they had messed up. That, as a longtime public defender, our clients were not in the habit of turning themselves in to the government when they had made mistakes. But it is a very common culture in the export field, in part because you need these licenses from the government, and you're getting them on a fairly regular basis. And I think these companies, the bigger ones anyway, and the ones that are kind of repeat players, realize that without a good relationship with the regulator, and that includes self-reports when appropriate, that they're not going to be trusted enough to get the licenses when they need them, to get the benefit of the doubt when they need them. And the other thing that in this area that I think is taken for granted is that the rules are so complicated that you will mess up. I mean, the regulators know that, the government knows that, and the penalties for messing up innocently or even kind of negligently at times are not that great. And so there's a huge amount of incentive to turn yourself in, because if you get caught and you haven't turned yourself in, the penalties go way up. And particularly if you get caught and you haven't turned yourself in and you knew about the issue and you didn't do anything to remediate it, the penalties can be significant. I think the other thing that makes it less likely that compliance is better in this area is the banks. So when we talk about the kind of the unique area of sanctions, banks have been at the forefront of sanctions enforcement, because the Treasury Department is the one that enforces the sanctions. And so their main target in sanctions enforcement is the banks. And as a result, banks have been hit with billions and billions of dollars in fines for failure to comply with various sanctions regimes. And virtually all the big banks have been hit at some point by OFAC. And so as a result, they have these huge compliance teams that are watching transactions for compliance and reporting to OFAC, or sometimes reporting to the Commerce Department. If they see non-compliance in these areas, they file these suspicious activity reports. And so the banks actually pay a lot of attention to this. And so even if there weren't this culture of self-disclosure because you're trying to build a relationship with the regulator, there's also this worry that if you don't self-disclose, the banks might tell, and you can get in a lot more trouble. And so I do think there is, especially among the repeat players, pretty good compliance, not 100% by any means. And I think, the smaller the company, there certainly are opportunities if you don't want to comply, to do things that you shouldn't be doing. I think eventually you'll probably get caught, but not necessarily.
Okay, so let me ask a slightly different question, and maybe this is going beyond lawyering, but just your sense from kind of working in this area and maybe having clients in this area. So, one of the issues that we hear about a lot with China is theft of intellectual property, and there's been some very highly publicized instances of, what appeared to be Chinese government-sponsored hacking of the U.S. government in some cases and U.S. businesses. And so, sort of taking those reports at face value, one might conclude that the Chinese government is sort of engaged in an ongoing effort to try to obtain, valuable technologies from the U.S. By non-legal means. And so, in light of that, how significant as a policy tool do you think these export controls are? And again, let's just, we'll turn to some other issues in a bit, but again, just focusing on kind of these national security, military type issues. Like, are we doing a good job at protecting our secrets and our weapons from a large potential adversary?
I think we are. I think we're doing as good a job as you could reasonably do if you're going to continue to trade. If you took the trade off the table, you might do better, but you would have other consequences. But I will say, so I've gone through the licensing process for, what are not the crown jewels of the military, but there's still a lot of licensing restrictions with respect to China, and it is there is very intense scrutiny on all exports to China now that go through the licensing process. And one of the things that is being looked at the most closely is this theft of intellectual property. What are the opportunities for that? And so, part of the licensing process often from the U.S. side is demonstrating to Commerce. But remember, so when Commerce is going to issue a license, particularly for China now, there's an interagency process. And so the Defense Department gets involved. And I can tell you, having been through that process a few times, the Defense Department is very, very concerned about the issue that you just raised with respect to military goods. And so their presumptive answer to every license is no. That is, you come in and really often, Commerce is much more nuanced with respect to China. I think they really kind of get it from the outset that some things are more likely to be military secrets than others, and some are going to have much more likelihood of being diverted or this technology being stolen. With respect to defense, they're always starting at no. And for understandable reasons. They're worried that whatever you're selling is going to then be used against them personally. And so I understand why they take this very seriously. And you've got to do a lot of work as a lawyer to persuade. Often it comes down to, can you persuade defense? Because if you get to the interagency review and the agencies are fighting, sometimes you'll prevail because Commerce has the final say. But usually if you can't get defense on your side, you're usually not going to get the license and not be able to do the export. And so it is, I think, to the extent the system is followed, it's a pretty good system for separating the wheat from the chaff. Now, again, that doesn't mean that somebody couldn't just go around the system. And so if you just started exporting these things to China until you got caught, that would obviously defeat the licensing process that is set up. But in my experience, that doesn't happen very often. And when it does, people do get caught. And so, the system, I think, works pretty well. If I had to say, I'd say it probably errs on the side of letting too few goods go out to China as opposed to too many.
Okay. Well, maybe we could shift the focus a little bit away from these sort of military and security issues and towards some of the other kind of hot button political issues that have been in the news, in the last few years, really. So what I have in mind is the accusations of very widespread human rights abuses by the Chinese government against Muslim minorities in Xinjiang region of China, the crackdown on democracy and civil liberties in Hong Kong that we all sort of witnessed last year. Maybe you could tie some of the sort of COVID origin dispute that is still sort of simmering in the background, I think still to be determined how that shakes out. But there are these other sort of large kind of hot button policy issues where the interests and principles of the United States might be seen as adverse to those of China. And these are other areas where we have used trade policy to try to influence things. So maybe you could say a few words about some of those issues and what the law of export controls are around those types of issues.
Sure, and for the most part, now we're talking about sanctions, and sanctions I think is kind of the most interesting part of export controls because I think, John, as you pointed out at the very beginning, you can read, if you read the paper on any given day, there's almost always articles about either sanctions or the potential for sanctions against various countries because it's the area that kind of breaking news transforms into trade policy the quickest. The export controls is a slow process, tedious process, methodical process. It's important, but it's very technical. Sanctions are not particularly technical. And so with respect to China, and we can talk also, I think, about the efficacy of these particular sanctions, because China is kind of it's an unusual country to be a sanctions target. I think that sanctions have, for the most part, worked best when they're multilateral and when they're targeted in an economy that is small enough that they'll feel real hurt from U.S. sanctions. And China is obviously huge, and the sanctions against China that we've imposed so far have been relatively controversial, even among our allies. And so that has made them much more of a rhetorical tool than they are in some other areas. So, for example, the sanctions against North Korea are kind of a classic sanction. So we have sanctions against North Korea where we have the UN is on board. It's a very small country. Sanctions can really affect their economy. China has not been a sanctions target, at least not since Nixon went to China, have not really been a U.S. sanctions target until very recently. But in the last 10 years or so, and especially during the Trump administration, but it was not exclusively during the Trump administration, and I think both the Obama and the Biden administration have kind of shown this same appetite, sanctions have been the preferred foreign policy tool. And so when in the Trump administration in particular, with respect to China, sanctions really got put back on the table with respect to China in a way that they hadn't before. And so when the autonomy of Hong Kong really came into question through the national security laws in Hong Kong, the U.S. response was to impose a series of sanctions against anyone that the government found was, the U.S. government found was involved in the oppression or the diminishment of autonomy for Hong Kong. And that was as a result of a congressional law that was passed by wide bipartisan majorities. I mean, sanctions is a very bipartisan tool. This is not a Republican or a Democratic tool, but in the U.S. they're very popular as a foreign policy tool. So the Hong Kong sanctions went into effect. What they do is they're almost symbolic in the sense that it's really a handful of individuals that have been sanctioned by the U.S. government for participation in the national security law, either on the Chinese side, and some of the Hong Kong governmental officials, including Carrie Lam, are on the OFAC, what they call the specially designated national list, the OFAC blacklist, and that means that she can't use the U.S. financial system. There's articles about how Carrie Lam now has to deal in she can't have a bank account, and she has difficulties kind of paying for things, and she keeps a bunch of cash at her house. And so, that obviously is not pleasant for her, but it really hasn't had much of a change in the Chinese governmental policy, and it's probably unlikely to, in part because it's a handful of, individuals and government officials, but in part because the Chinese economy is so big and the Chinese financial system is so big, and these sorts of sanctions arguably don't apply to those entities, that they're just not very effective. But that's been one aspect of it. Another aspect of another new OFAC sanctions policy in the Trump era was this. And again, it was pursuant to a congressional law, so it wasn't just a unilateral decision by President Trump, but was the sanctions against to try and deter the human rights violations going on in Xinjiang province with respect to the Muslim community there. And so there's the OFAC part of this, and the piece that is the import side is a much bigger, much more, I think, important and effective tool in the supply chain side. But the export piece is that there are now a number of individuals and companies that are either on what the Commerce Department's entity list, which is a list of companies that can't get U.S. origin goods without a license, or OFAC's SDN list, which is a list of people that are off limits to U.S. persons. And so that is the foreign policy tool that has been used in those two places. And again, it's much more symbolic because we either weren't exporting a lot of things there, or because, as a practical matter, those companies and individuals can get their banking or get their supplies from somewhere else.
So, you said a couple of times there that you sort of see these economic sanctions when they're directed at China as largely symbolic moves, just because of the size of the Chinese economy, and I guess because we're doing them sometimes unilaterally, so they don't apply to businesses in other countries. And even though we're a major trading partner of China, they trade a lot with other countries as well, right? So why do you think it is then that we turn time and time again to trade sanctions as the response to these types of problems? Is it just because we don't have another tool, and so we just pick the one that, even though it's ineffective, it's the least ineffective? Or is there something else going on?
No, I think it's kind of the latter. So I think that the tensions between the U.S. and China 50, 100, 200, 300 years ago, you might have had a shooting war at some point, because trade disputes in the past often turned into shooting wars. I mean, the end of the story with respect to the Embargo Act of 1807 was that it was a completely ineffective tool, and so the U.S. and Britain ultimately, over many of the same issues, got into the War of 1812. And so I think that, because, and thank goodness, shooting wars have become seen as mostly off the table in these circumstances. And you also, in democracies in particular, you kind of have this desire for the government to do something, because what China is, by many reports, doing in Xinjiang province, and what they're doing in Hong Kong, and even this Chinese military civilian fusion that's going on, where a lot of the goods from the civilian sector being diverted to the military, all that stuff is bad, and you want your government to be able to do something about it. And with respect to a country like China, there's not a lot of options. And so I think that to add one more tool to that, the president has the ability to just unilaterally go in and impose this sort of sanctions program through OFAC, especially when they've got express congressional authority, which happened with Xinjiang and with Hong Kong. But even when they don't, because there's this law called the International Emergency Economic Powers Act, which allows the president to declare an emergency, and they do it all the time. Many of the sanctions programs are created from, the president declares an emergency and then just imposes sanctions through OFAC. And so even without those other specific statutes, it gives the president the power to do something quick when people are upset for understandable and justifiable reasons. And so I think that is why you've seen this tool used with respect to China quite a bit in the past. And one of the things that was interesting about the Biden administration when it came into power was there were a lot of questions about whether that would continue. So the 2 or 3 new sanctions programs that President Trump had adopted with respect to China, and there was one in particular that was very controversial, there were a lot of questions about whether Biden would keep that up. And he did. I mean, that has been a very consistent theme between the two administrations. And I don't think it's one where you can just say, well, that was, President Trump wanting to pound his fist on the table and do something about China. And President Biden's doing the same thing. And I think it's responding to a public outcry because things are happening bad and people want their government to do something about it.
Yeah. I mean, and it does feel to me like there is a sort of a risk that we're taking that that we're sort of counting on these trade relations to sort of moderate the other conflict points between our two countries. That somehow, there's this assumption that we can't ever go to war with China because shutting down the trade between the two countries would be existentially bad for both sides. But maybe that's a good thing. We don't want a hot war with China. I'm sure it would be terrible. But it also puts us in this awkward position of sort of having very limited leverage to affect things in China that we see as negative, like these human rights abuses. It sort of feels to me like it's kind of like the international relations version of too big to fail. Like this economy, the Chinese economy has gotten so big and we're so interconnected with it that we've sort of lost the ability to have any real influence over what goes on in that country. And maybe we just have to live with those consequences. I don't know. How do you see that?
So I think that's right. But I will say, I think the issue to watch in the next 10 years with respect to the overuse of U.S. sanctions, and particularly in China, is whether sanctions as a tool become much less effective from the U.S. perspective. So the main enforcement tool for the U.S., and the reason that they are so effective, is the banks. So OFAC has made itself known to the banking system around the world. And the main tool that OFAC uses as its sanctions policy is to cut off foreign actors and foreign individuals and companies from the U.S. banking system. I mean, that is, if you're on the SDN list, especially the OFAC blacklist, the punishment is you can't use the U.S. banking system, and anybody who lets you use the U.S. banking system will be cut off from the U.S. banking system. So it's a pretty powerful tool, but it's only as powerful as the U.S. banking system. And the bet from OFAC's side is that people want to use the U.S. financial system so much and want to be integrated into it that there won't be any kind of negative consequences. There won't be collateral consequences of this. China's setting up its own financial system, and then you also see the rise of cryptocurrencies as well. As China sets up its own financial system that is in some ways distinct from the U.S. financial system, at some point the sanctions will be much less potent of a tool because if people don't care if they're cut off from the U.S. financial system because they can just go use the Chinese financial system instead, you've lost your most powerful tool, not just against China, but against many other countries.
Yeah, that's an interesting point. I hadn't really thought about that. So maybe you could say a little bit more about that. What is it about the U.S. financial system that makes it, at least now, unique? Like, why does a business or a wealthy person in China have to deal with U.S. banks?
It's an interesting question because the answer is I'm not sure. But the Chinese, at least until recently, the Chinese have felt very strongly, and the Chinese banks as well, seem to have been very concerned by being cut off from the U.S. financial system. But as China's financial system grows, and really as it gets interconnected with the rest of the world, I think that's really been the reason that China hasn't kind of built its entirely homegrown financial system independent of the U.S. is because China wants to trade with everybody else, and everybody else wants to be part of the U.S. financial system. And so if China had this kind of rogue outlaw financial system that China was using exclusively, they'd have a much harder time trading with the rest of the world. Certainly Western Europe, which still lives in great fear of being cut off from the U.S. financial system. And so sanctions are a very, very effective tool with respect to businesses in Europe because they view it as a death sentence to be cut off from the U.S. financial system. And so if China had its own rogue system, nobody from Europe, I shouldn't say nobody, but European companies would be very scared to deal with it if the penalty for dealing with it was being cut off from the U.S. financial system. I think if they had to choose, right now they'd choose the U.S. financial system. And because China knows that, they don't want to get too crosswise with the U.S. financial system. But that's starting to change. China is doing a lot of trade with Iran right now in the oil industry that is technically still under sanctions. The Chinese-Iran oil trade has gone up in the last 2 years, even despite the sanctions, quite a bit. And it just is starting to show that China is starting to be less and less afraid of being kind of cut off from the U.S. And its banking system, they've started to create an electronic currency that is government controlled, the Chinese RMB, but it's a digital RMB, and the thinking is that they're moving towards kind of making people choose at some point and thinking that they'll get the better half of it.
Yeah. I mean, it feels to me like a big sort of shift in sort of the way the United States operates in the world. I mean, certainly compared to what things were like during the Cold War, right? I mean, if you think back to the 70s and 80s when you and I were a little younger, the United States role in the world, at least as we like to portray it, was that we were going to advocate for democracy around the world, and we were going to fight totalitarianism and communism wherever we found it. And now it does seem like that's not realistic. Like that we're going to have to almost accept that there is this other world power that controls a huge percentage of the world's population, and that it just has a very different political system than ours, that has a different view of democracy and a different view of human rights, and that we're just going to have to live with it. I mean, I kind of almost hear you that's what I kind of hear you saying. Like, there's nothing we can really do about it. We can't go to war with them because it would just be devastating for everybody. We can't really influence them economically because they're too big. And so, where does that kind of leave the United States from a sort of foreign policy perspective?
Well, I mean, I don't want to sound too pessimistic about this. I don't think sanctions are the right tool against China. I will say that, at least to some extent, although that shouldn't. I do think export controls are actually a pretty good tool against China, because I do think that, they serve an important purpose of at least trying to maintain whatever technological edge that you have, and one that is generally respected by the rest of the world. It's the sanctions that are much more controversial, particularly when they're unilateral. But even if sanctions isn't the right tool, I mean, I think the way that the U.S. wound up kind of coming out on the right end of the Cold War was to establish a model of governance and work with allies to kind of create its own sphere of influence and allow kind of the world to choose, would you rather be with us or would you rather be with them? And at the end of the day, that worked out pretty well. I don't think that's the path that we're pursuing right now, but I do think it was a path that worked pretty well in the Cold War, and could work again.
Yeah, we'll see. I guess we'll see. It's going to be certainly an interesting few years in U.S. China relations, I think. I think folks in your little niche of the law world are probably going to be working on some really interesting high-profile issues. If there's something about the system that you could just wave your magic wand and change right now, what would it be?
So, and this doesn't necessarily relate to China because the sanctions are so new, but I do think that, Cuba is a good example of this, that there ought to be some mechanism in the law to revisit sanctions policy periodically. I'm not sure what the right term is, and I'm not sure what the right mechanism is, because on the one hand, if the targets of sanctions knew they were going to expire after a certain amount of time, there'd be this incentive to wait them out. But I think that sometimes we impose sanctions for no apparent purpose, and they go on for decades for no apparent purpose. And I think if there were some mechanism in the law that would require the government to revisit sanctions at some point and either get full congressional authorization or to kind of have a metric to see whether or not the sanctions are worth the cost. And in particular, I mean, and it's not the Cuban sanctions specifically, but all sanctions right now have a real catastrophic effect on the people in those countries that we've tried to mitigate, and to some sense we have. I mean, under sanctions policy, it actually, there's humanitarian exceptions that are supposed to allow for food and medicine trade with even sanctioned countries like Cuba and Iran and those sorts of things. It's a practical matter, those exceptions don't work because the banks are so scared of getting crosswise with OFAC that you really can't do trade in those countries because you can't get the financing for it. And so I wish there were a mechanism in the law to really revisit old sanctions programs, because I think they get a momentum of their own. They do a lot more harm than good in some instances. They don't change behavior over a long period of time, and there really isn't any particular behavior that seems to be targeted for change. And so they just hang on and do a lot of harm and don't do a lot of good.
Yeah, and I think you're right that just like in a shooting war, the citizens of the countries that are involved end up becoming the victims of the decisions and actions of their governments, and we should never forget that those people that live in those countries have their own humanity, and that we shouldn't demonize those people just because their governments are doing things that we don't like.
Yeah, and I think the term governments that you used is important. I'm not saying that these kind of collateral harms are necessarily all the responsibility of the U.S. because it imposed sanctions. The governments that are targets of sanctions do a lot of terrible things, often to their own people, and so the fact that they were the subject of sanctions in the first place is often their fault, and so and they often don't change their behavior because they really don't care about those sorts of consequences to their own people. So I think there's a lot of blame to go around.
Yeah. So Tim, this has been a really interesting discussion, and I think a great introduction to this sort of interesting and really important area of law that probably most people don't know that much about. Now, if they wanted to learn more about this and get really into some of the nitty-gritty, I know that you and one of your colleagues at your law firm have their own podcast that is really devoted almost exclusively to these issues, right?
Exactly, John, and thanks for the chance to pitch the podcast. So we have a podcast called Embargoed with Brian Fleming, one of my colleagues, and we basically spend about an hour every couple of weeks talking about kind of the most pressing U.S. sanctions export control issues. And it's often, the agenda is often based on what's going on in the newspaper. So right now we're talking a lot about the potential invasion of Ukraine by the Russian military and what some of the sanction consequences could be arising out of that. But it's something that if you're a real trade nerd and want to get very deep into this, you should come give it a listen.
Yeah, and I would say don't sell yourself short. I'm not a trade nerd, although I touch on it a little bit in my practice. But I listened to some of the episodes and found it just really fun to listen to. You guys have a great rapport, and it's just a fun podcast to listen to. You can't necessarily understand every little detail once you guys start citing this section and that section of the regulation, but it's fun to listen to, and I think these issues they just intersect with so many things that are going on in the world that are interesting, that it just kind of adds a little flavor to that. And if people are going to search for it, on their podcast app, it's Embargoed !
Correct.
That is the show. Like it was a Broadway show. So think about trade lawyers doing a kick line or something like that. That's what this podcast
We'll
is.
have to have a segment like that.
And I did listen to a few episodes, and it was much better than Cats, and I will listen to it again and again.
Well, thank you.
And if you got that joke, you're old. So so let's now turn, as we do always on the Garrulous Gavel, to learn something that isn't about law, about our guests, just to prove yet again that lawyers are fun, interesting people. And so when I asked him what he wanted to talk about, he said, well, somewhat sheepishly, he said, well, I was in a band when I was in college. So Tim, start out with this. What was the name of your band?
So my band was called Birch Bark Canoes, which had a little bit of a symbolic meaning. So I was involved in naming it, and I used to go up every summer and spend my summers in Wisconsin, and often used to canoe, and occasionally used to canoe in Birch Bark Canoes. So it was good childhood memory, and we thought it was kind of a cool name for a band at the time. And
so this was when you were in college?
This was when I was in college. So this was Charlottesville, circa 85, 86, 87.
All right. And what instrument did you play?
I played rhythm guitar. There were four of us in the group. We had a drummer, we had a bass player. A bass player I had known since I was 8 years old. So we went to school together at UVA. We'd been playing music together a long time, and then met up with a really good lead guitarist who I see all the time still. And then a drummer, which is always the hardest to find, because
Why is that?
who carries around a drum kit with them? So it's really hard to find somebody who's in college and actually has a drum kit that they can continue to play and bring to gigs.
Right.
So,
You just need the equipment. You don't really need because what do the drummers do anyhow? They just
right,
hit
exactly,
the drum over and over
exactly.
again. Not that complicated. um, so what kind of music did you all play?
So, think 80s. I think we would call it kind of alternative music at the time. This was kind of a fusion between kind of new order type. I think they were calling it new wave at the time, because it was kind of the post-punk British kind of meets what they were calling is Southern college rock. So REM was kind of the classic example of that. They were down in Athens, a couple 100 miles south of where we were, making a lot of good music. It was before REM became as big as they ultimately became. But
yeah, I mean, you're reminding me of something that I had totally forgotten about. There's a whole cultural phenomenon that's now probably gone, right?
Yeah.
Which is, there used to be this thing called college radio.
Totally. We actually appeared on our college radio station, WTJU, all the
And
time.
so some of that work was literally radio stations that were run by college students,
Yep.
like small local radio stations. But from what I recall, even some of the bigger commercial stations, like they would have an hour or two at night, like late at night, where they'd be like, and now we're going to play, some songs that are hot on college radio.
Yep.
Right. And so these little college radio stations were kind of where, less mainstream bands, or bands that had like a sort of a new sound, could get some play.
It's such a different time. I mean, the internet changed everything, but it especially changed the music business, because the whole trick was, being able to record, which is now so much easier even from your home. And then even if you got something recorded, where would you get it played? I mean, you couldn't just put it on to, YouTube or to Instagram or wherever you want to put out your music and, kind of put it out there. You'd have to try and go get airplay on a radio station for anybody to ever hear it. And the college radio stations were great for that. But kind of, I think their time may have passed in the sense, because they've been replaced by the internet.
Right. Yeah. So did Birch Bark Canoes, did you guys have an album?
We did. We had two albums. We had our first album was called Canoe Wave. And then our second album was called Tumbleweed.
And did you guys get some play?
We did. We got a lot of play on the local radio stations, and then we were able to travel around and get play on some of the other college radio stations in Virginia and then a little south. We actually played down in Athens at some point, and then after we went off in various directions when we went to grad school. We in the 90s, after the internet came about, we actually were doing some Google searches, and our music was showing up in all sorts of weird places, including like we found like some radio station in Lithuania that had it on the playlist for a while. I haven't been able to recreate that recently. I actually looked a couple of months ago just to see if I could find it anywhere, and haven't been able to. But in the 90s and even into the 2000s, it was findable on the internet.
So now, but if I go look for you now, I won't find it?
I don't think so. I mean, so the last time I looked and found something was about 3 or 4 years ago. There was somebody wrote for the UVA paper. They wrote a history of kind of the rock scene in Charlottesville from like the 70s up through the present, and we were mentioned there, and they actually talked about some of our songs. But the last time I looked, I wasn't even able to find that, so I haven't found any trace of us anymore.
Who has the rights to the music now?
It's very unclear. We recorded. We kind of gave each other all sorts of CDs, and then we've downloaded them to iTunes, and so I've got it digitally still, like on my phone. But who has the rights is a really difficult question right now.
Like if you just want, you could just take. People put CDs up on YouTube, right? I mean, like, could you just take your CD, burn it onto a computer, and put it up on YouTube so I could listen to it?
We totally could. I mean, the problem would be the former bandmates and the tech, but we definitely could put it online. We probably should do that. We've talked about doing it at some point.
Yeah,
but
you absolutely should. And so, have you kept up with music since then?
some, especially during the pandemic, I've been played more than I've played over probably the last 20 years or so. But still not as much as I was in college. I think I mentioned before we started talking that I had tried to recreate some of our old songs and had a difficult time keeping up with myself on the guitar. My 20-year-old self was a lot better at guitar than my 50-some-year-old self is.
All right, so I've got to ask you this as like an '80s kid. So like, tell me who were your like 3 favorite bands or musicians in the '80s?
So it's a hard question. I mean, we were in love with REM, so REM was definitely at the top. But then there were definitely New Order and Joy Division, and then a band that was not really of the '80s but was like hugely influential was the Velvet Underground and Lou Reed. So you just couldn't do that music without being influenced by them.
Yeah, that's all great stuff. And I can remember Joy Division and New Order and as I said to you before we got on, my recollection is that was the music that the cool kids listened to when I was in college. It never got like a ton of airplay, but people knew who those bands were. They had kind of a little bit of a cult following. There was like one club up in Baltimore where you could go to and listen to that kind of music. I think it's actually still there, maybe called the Depot. Did you?
Yeah, I mean, there's still the 930 Club in DC. I think it was another place that you could listen to that kind of music in, which is still around. It's playing some different music now, but
yeah. So that's really interesting. Well, I would definitely encourage you to like figure out how to get it up somewhere. I mean, just to preserve it for history's sake. And you just never know when somebody's going to want to go back and find it.
Absolutely.
Some fan you had 30 years ago has been Googling you ever since and can't find that one song that they've never been able to get out of their head.
We'll have to do it. Do it.
Yeah, that would be great. And I think you told me that a little bit of your music has lived on as the theme song to your podcast.
That is a first time revealed secret. Yeah, the intro music on our podcast is Birch Bark. It's actually Tumbleweed. The title song from our second album is the lead-in music to our podcast and the outro music as well.
Oh, that's great. Well, the music we use on my podcast was composed and performed by my brother, who's a very talented musician.
Oh, that's great.
And I told him I was doing a podcast and that I needed some music. And so he wrote that out. And so that's like podcasts are a great way to kind of like get a little musical talent out there, sort of.
And you don't have to worry about the copyright issues too.
Right. I have to stay on his good side so he doesn't sue me for violating it. But well, that's great. Well, thank you for sharing that story, and I look forward to seeing Birch Bark Canoes on YouTube sometime.
We'll do our best.
All right. Well, thanks again for being on the podcast. And I think this has been a really interesting, fun conversation. I hope you've enjoyed it. If people want to learn more about you or find out how to contact you, if they've got questions or they've got a need to hire a lawyer who does what you do, or want to ask you about 1980s new wave music, how can they find you?
So I'm pretty easy to find. If you just Google my name and Miller Chevalier, and my page will come up, and it has all my contact info, including my cell phone number. So give me a call.
And does your podcast have like a web page that has all?
It does. Episodes? There's an Embargoed page as well, so you can go to that page too, and you can find me pretty easily from there.
Okay, fantastic. Well, we'll put links to both of those pages in the show notes to this podcast episode. And Tim, it was great. It was great meeting you remotely. I hope you enjoy the rest of your time up in Canada. And thank you so much for sharing a bit of your time and a bit of your knowledge and your experience with us. It's really been a pleasure.
It's been a real pleasure. Thanks for having me, John.
Thanks. Thank you for listening to this episode of the Garrulous Gavel. If you enjoyed it, please subscribe wherever you listen to podcasts. You can always find us at garrulousgavel.com. If you'd like to send feedback or suggest a guest, please contact us at our email address, garrulousgavel@gmail.com, or on Twitter at garrulousgavel. Our cover art was created by artist and illustrator extraordinaire Joan Tico. Our theme music was written and performed by scientist and saxophonist extraordinaire Robert Tico, and our producer is the inimitable K.O. Myers of Particulate Media. See you next episode.